All right, let's see. Now we get to the guidelines, and please, again, interrupt me if you have questions. These are just some basic guidelines for every advertiser to be thinking of. First of all, like I said before, step back and review the ad. What is the message you're conveying? And be sure to review the ad from the perspective of the consumer and the competitor. Obviously, if a consumer is getting a message, you need to pinpoint what that message is that's being conveyed, and you need to make sure that it's true. But be very careful with competitors. Competitors are the people that are paying attention to this, not the consumers. So if someone's likely to bring a claim, it's them. And so from that perspective, it's if you put yourself in their shoes, how will they react? The context we talked about, health and safety issues, are predominant and are red flags. There was a great a case I read that was someone in 2000, a pest control guy in New York, advertised saying, "My mosquito control services are, quote unquote, extremely effective in the elimination of mosquitoes carrying the West Nile virus." Right? So it probably would have gone unnoticed if he just said, "I'm an extremely effective mosquito killer." But because he put West Nile virus in there, the New York Attorney General at that time picked up on it. The guy got investigated. Fines were levied. It turned out he wasn't even certified to be a pest control person. He wasn't properly certified. And he was using a substance that was not a certified substance for the control of mosquitoes. So it probably was an extremely effective method, but illegal though. And so the turning point on that case was the fact that he said West Nile virus. Had he not said that, it probably would have gone unnoticed. Red flags, obviously free, guaranteed, any kinds of words like that are quantifiable. Or I see some grimacing over here, but to be careful of those. And then finally, nothing will raise the attention of a competitor more if you use their trademark in comparative advertising. And so that's just a very key. That is the most sensitive type of advertising that's done, is if you use a competitor's trademark. I'll give you one last case study. Werther's sued Lifesavers. Lifesavers, the packaging said, uses 20% less sugar than Werther's Original. And they used the Werther's Original name right on the packaging. The court found that the court found there was no false advertising in that case, because it was clear enough. There was a stripe on the package, a diagonal stripe that says 20% less sugar than Werther's. Werther's was taking the position, well, you know, you're creating this false impression that I'm involved in this, or this is somehow affiliated. You can't use my name without permission. And the court said no. A reasonable consumer knows that when this stripe is going across the top of the packaging, that, and you know, this is Lifesavers. This is one of the most famous brands in the country. There's no confusion that this package contains Werther's products. And so, but nonetheless, that was a hotly litigated case, and it was actually a close call. The district court disagreed with the appeal court, so that was a lot of legal fees, a very expensive decision. And so anyway, be wary when third-party trademarks are in use.
Jay, moving back up to the free and guaranteed, that's kind of a buzzword right now on a couple of things we're working on. As long as it can be substantiated, the guarantee can be backed. And as long as free can be substantiated with a disclaimer or something, it's okay to do.
That's right, absolutely. It's when it's misleading and false that you have a problem. So, but let me say this, as a best practice, what we find the best advertisers and agencies doing is keeping track of it all, making sure that it's substantiated and kept in a file, so that if it's ever challenged, you're ready to roll out your evidence right there. Whether it's a scientific study or something that's substantiated as free, a statement by the company, and so forth, as to the freedom of the free character of the product. So anyway, that's the presentation, and I hope that
don't leave this,
Jimmy. Well, anyway, the next slide says questions. So.
How long do you have to keep that as substantiation?
As long as the ad runs, for sure. I wouldn't think you'd ever want to get rid of it. I think you'd want to lock it up in a file and keep it somewhere permanently. But I think as long as the ad is running, you want to have it handy, very handy. Yeah.
In regard to puffery and the term best, you had mentioned when you gave the example of the best waterproof.
Yeah.
You said they just would have said best and left out waterproof. It probably would have been fine.
Right.
So every now and then some magazine do a survey or something, and you're voted best
Best lawyer in Atlanta. No, just kidding.
Is it always then disclaimed as voted by, Atlanta Magazine or something?
Well,
could you say on the best lawyer?
I think, lawyers have a specific, I'm not even allowed to say these awards, I'm not even allowed to list them on the website because lawyers have a specific ethical guideline that comes from the bar that says you can't do that kind of thing. But I think from a false advertising perspective, other than the fact that it's false, I could probably say, no, I mean it would be viewed as puffery to say best lawyer in Atlanta. I think that would probably be viewed as puffery if under normal false advertising principles, because it's objective. I mean, it's not objective, it's subjective, it's opinion based, it's not verifiable, and so,
It sounds like you get in trouble when you try to verify it.
That's right.
That's
right.
What I've heard from your situations where if they had just said better ingredients and not tried to validate, they would have been fine.
Exactly. Better ingredients, better pizza, no problem. But when you try to say, here's why they're better, then you're getting into the area of,
third-party endorsement, and I'm going to specifically think about advertising, you can get the Good Housekeeping seal of approval. Basically, all you have to do, for the most part, is buy a page of Good Housekeeping magazine.
It's like AAA.
Jake just grimace when you said that.
And I mean, seriously, you can do it. They take it through their testing process at the Good Housekeeping Institute.
Right.
But then that gives you the right to put that seal
that's right.
on your ads, which is an implied endorsement.
Well,
I think.
That's called certification marks. What you're talking about is certification marks, and they're all manner of certification marks. UL, Good Housekeeping Seal of Approval, ISO, those kinds of things are all, the key to those is really the standards and the testing that takes place. Now, I assume you may think you may be more cynical than me, but if I buy a page in the Good Housekeeping magazine, but my product fails the testing, they won't give me that seal. Right. So the testing is the key. As long as it meets the testing, then there's a trademark license for the use of that trademark, and it's very particular. The size has to be right, the proportion, the colors, and there's a style guide and so forth. But certification marks are an interesting subset of trademark law. And if you use them without proper justification, then the trademark owner can come after you, and it's false advertising as well.